I will go ahead and start the presentation. So when you talk about an EB-2 visa, we are talking about a green card. So if you are successful in your application, eventually you will get a green card. A green card is basically a visa that will give you all rights to work in the US for any employer, to work for yourself. You can bring your spouse, you can bring your children under the age of 21. You can eventually become a US citizen. So the green card will replace a work permit that you have that is temporary, will replace a visa that allow you to study in the US and so forth. So it's the document that will give you the freedom to travel. It will give you the freedom to work in the US and also, as I said, eventually become a US citizen and then receive all benefits that a US citizen receives. Of course, you're not going to be able to become a president of the United States because you were not born here. But other than that, you're going to have all rights and, of course, all rights and responsibilities of a US citizen that was born in the US. This is one of the few types of green cards that you can self-sponsor, meaning you don't need an employer, you don't need someone to ask the government to give you the right to come to the US and remain here on a permanent basis. However, in order to do so, you have to convince the government that with your stay in the US, you are bringing a wealth knowledge, as well as you are creating jobs, you are developing new technologies, you are impacting the industry, you are impacting the United States as a whole. And in order to do so, the basic requirement is that you either have an advanced degree or you are a professional with exceptional ability. And a lot of times when you research online about the EB-2 NIW, you see the exceptional ability being discussed a bunch. However, as I said, you don't have to be someone with exceptional ability to qualify for the EB-2 National Interest Waiver. You can also be an individual with an advanced degree. And what does advanced degree mean? It means that you either have the equivalent of a US master's degree, or you have a bachelor's degree plus 5 years of progressive experience that you attained after you graduated, okay? So if you have 5 years of experience before you got your bachelor's degree, this does not count. That will count towards the exceptional ability classification, and I will discuss further, but it will not put you under the advanced degree criteria. The advanced degree criteria is easier to argue, it's easier to justify, it's easier to meet the requirements because it's very objective. As long as you have that degree, or as long as you have that degree plus 5 years of progressive experience, you would qualify under the EB-2 NIW. Now, that experience must be related to your field of education. So, for example, if you have a degree in engineering, but your experience is with sales of pharmaceutical products, for example, that would not make you qualify for the EB-2 NIW under the advanced degree category. You would have to look into the exceptional ability category. Also, a lot of the times you would have a master's degree that you attained in a country that the US would not recognize as equivalent to a US master's degree. For example, a Master's of Business Administration from a Brazilian university, usually it's not considered the equivalent of a US master's degree. Some of them, yes, but the majority of them, no. The US government will just identify it or recognize it as a short-term course and not as a master's degree. So when we talk about a master's degree, make sure that before you initiate the case that you get a company in the US that evaluate degrees. to make a determination that that degree is equivalent to a U.S. master's degree. Same thing goes with a bachelor's degree. People, for example, from India or people that get a degree from the UK, sometimes those courses, even though they have a bachelor's degree, a bachelor's in their diploma as the degree they have attained, because they have a duration of 3 years, a lot of the times the US would not recognize that as the equivalent of a US bachelor's degree. Okay, so, and then for the 5 years of progressive experience, what I have seen is that immigration is looking for employment verification letters instead of just relying on resumes. In the past, I would say 7, 8 years ago, we used to file NIW petitions with just the educational documents plus the resume, and that would satisfy the 5 years progressive experience requirement. So if you are looking into the advanced degree classification, the first thing that you have to do is talk to your previous employers. If you are self-employed, proof that you are filing your taxes as a self-employed, and also letters from clients, vendors, justifying that you acquired that experience related to your field of experience via letters of recommendation or letters of experience. Now, if you don't qualify for the advanced degree, your last resort would be qualify under the exceptional ability classification. So for the exceptional ability classification, the law itemizes six type of evidence that you can provide to prove that you have that exceptional ability. So out of those 6, you have to prove at least 3 of them, but then you also have the subjective requirement that I will talk about after I go through the 6 items that you can provide to justify that you have that exceptional ability. The first one, the most common one, is you showing that you have an education, a certificate, a diploma that is related to your field of expertise. So for example, if you just have an associate's degree, or if you only have a bachelor's degree but no experience, for example, you can use that education towards the justification that you have exceptional ability. Then the second most common type of evidence that you can provide is proof that you have at least 10 years of experience in your field of endeavor. And then, as I said, for the 10 years of experience, you have to get letters of experience from your previous employers, from your clients, your vendors, to justify that you got those 10 years of full-time experience. The third one, I would say the third most easiest one to get is proof that you have professional license to practice your profession. So for example, if you are an engineer, or if you are a lawyer, if you are a doctor, then you have proof that you have been performing those duties, that professional, in a professional capacity, based on a license that you have acquired. The fourth one is proof that your earnings are way, way beyond what your peers they earn. So that threshold is not like the extraordinary ability EB-1 visa that talks about being paid in one of the top 10% highest earners in the field. That one is basically, we have to usually, I will compare our client salaries with the average earners, or at least like top 40% earners in the field. The fifth criteria would be you showing that you have created something, or you have contributed to your field of endeavor, the industry, and that contribution is considered major, is considered impactful. So it's something that not only you have helped the company or the project that you worked on, but through your work, the whole industry was impacted. So, for example, if you have a patent, or if you have, of course, not just a patent that was accepted, but a patent that has been commercialized and it's being used, or you have developed a technique that you wrote a best practice manual, and the whole industry is using this manual to perform, the other professionals are using this manual to perform their duties and so forth. So that has to be, when we are talking about here that major contribution, that somehow also it's going to be used as well when we go into the matter of the NASA criteria that I will talk about in a few moments. So all the efforts that you put into writing those letters of recommendation regarding your major contribution to the field, that will be used for other criteria as well. And then one other type of evidence that you can provide to show that you have exceptional ability is, for example, if you show that you have a role, you have a position within a company that is considered managerial, executive, or if you are considered essential for the operations of the company. So that's usually what you would show to provide enough evidence that you have the exceptional ability. However, there is the subjective requirement along with those objective requirements for the exceptional ability classification, which is showing that you have maintained that type of recognition throughout your whole career. So it's not something that it happened in the past, but it's something that you have kept steady throughout your whole career. So that's very subjective, of course, but with evidence, if you show through, for example, your letters of experience, your letters of recommendation that you have started and then you have progressed, you have from the time that you graduated, from the time that you started working, now you have bumped into the career, and you have now positions that in the corporate world of multinational companies, or even like if you are a business owner, the type of duties that you are involved now are more complex than the duties that you were involved before. So that's how you show that you have maintained steadily that recognition throughout the industry. So as I said, being an individual who has an advanced degree or an exceptional ability is just the basic requirement to qualify for the EB-2 National Interest Waiver. Because you are requesting the government to give you a green card without a job offer, you have to show that the contributions that you're going to bring to the US are so major that the government cannot deny your entry into the US. It would be in the benefit of the United States citizens, to have you as a professional in the country, because you're going to be creating more jobs, or you are making the lives of the US citizens better, or that you are creating something new, or that you are developing a new technology in the US, and then it's putting the US in the forefront of a specific industry. So you have to show that you are coming to the US to bring some value. You are not someone to come into the US just to have, just to benefit your family or your own. You have to benefit the United States. And how can you prove that? There is a case law called Matter of Danassar that sets forth the 3 criteria that you have to convince the United States government that you have met, in addition to being an advanced degree professional or an exceptional ability professional. So the first one is that your field of endeavor has national importance and substantial intrinsic merit. So your field of endeavor is basically a statement that you set forth what is your intention, what you aim to do while you are in the United States. What are your plans? What is your goal as a professional? All right, so it's not your goal on a personal level. So if you want to attend school, or if you want your kids to have a better life, if you are looking for security, that's not what the government wants to know. The government wants to know what are you bringing of value professionally to the United States. So the first thing is that that aim, that goal has national importance, that goal has substantial intrinsic merit. As I said, the impact has to be on a national scale. It cannot be an impact on a regional level. It cannot be an impact on a city level. It has to be national. And I can give you some examples as we enter the Q&A session of how this impact is perceived by the US government. Then secondly, you have to provide evidence that you are well positioned to advance on that field of endeavor. What does that mean? It means that you have a plan, you have an action, you know what you're going to implement in the US to make sure that the United States will benefit it on a national level. So one, you need to have a plan, either a business plan if you want to be a company owner, or if you have a professional plan, if you want to be someone that will provide services as a consultant, or you plan to work for a company, for example, you need to have a plan. So what are you going to be doing the next 5 years? What will your company be doing in the next 5 years? How many people will that company hire? How are you, through that company, impacting the whole industry in the US, and not just your employees, not just your company that is sitting in Houston, Texas, for example. And if you are a professional, how are you impacting the industry beyond the services or products that you are selling to your clients, your vendors, or your employer? So that's how you show how well positioned you are. And then, of course, if you are a professional who has that know-how as of today, you have to show proof how you attained that level of knowledge. So you have to look at your past. So when I explain to my clients how we develop the whole history of how they are well positioned to advance on their field of endeavors, I talk about the past, I talk about the present, and I'll talk about the future. So how you started and what made you the person that you are today. That's how the government will be convinced that you are well positioned to develop on your field of endeavor. The other thing too that you have to consider when you are talking about how well positioned you are to develop in your field of endeavor, you have to provide proof of any interest from investors, from an employer. So if you have a job offer, if you have a letter of intention, if you have someone that is willing to partner with you when you come to the US to sell a product or a service, or if you wanted to teach at a university, whatever you want to do in the US, if you have some type of shotgun evidence, that's how I call it, from someone in the US that is willing to do some type of business with you, that letter will be super important for the process. And then, of course, if you don't have that, your business plan, your professional plan, your personal statement will be that shotgun, because it talks about what are your plans to develop your field of endeavor on your field of endeavor in the United States. And then the third criteria is you have to show that on balance, it is beneficial for the United States to waive the requirements of a labor certification. And what is that, Bruna? What is labor certification? Labor certification is a process that a U.S. employer will have to go through to hire a foreign citizen. So if you have a job offer, the most common type of green card that you have to go through is the PERM, also known as labor certification. So that the employer will have to advertise the position, and then will have to provide to the Department of Labor that there are no U.S. citizen or green card holders that are available, interested, or capable or qualified for the position. And then in that case, since you don't need a job offer to qualify for the national interest waiver, you're going to show that the United States has some type of urgency to maintain you here, to bring you over, because the United States cannot wait any longer to bring you over, and the United States cannot afford to have you going through the labor certification process that is very lengthy, or even having an employer to go through that process, which requires commitment, because the United States has this urgency to bring you over. Now, there is no specific evidence that you can provide to convince the government that that criteria was met by you. The government usually will look at all the evidence that was presented for the other two criteria, and then make a determination based on that evidence, right? So there is no, if you look at case law, if you look at even RFE templates that the USCIS provides, you never see a list of evidence that you can provide to overcome that deficiency. All right, so just to recap, to qualify for the EB-2 NIW, you need two things. One is show that you have advanced degree, or you are a professional of exceptional ability, or in that you qualify under the three criteria set forth by Madoff-Nassar. Okay, so this is the most subjective part of the national interest waiver application. The first one is more objective, especially if you are convincing the government that you have advanced degree. The exceptional ability category has that small hoop that you have to go through, which is showing that you have steadily maintained that level of recognition within the industry. And that's it. Okay, so that's the EB-2 National Interest Waiver. Now, as I said, the most common type of evidence that you're going to be providing are your educational documents, your certifications, training documents, if you are someone that works in academia, publications, participation in conferences, prizes that you have won, citation of your work, if you review papers of your peers, if you are invited to give presentations, all that will count. If you are someone that is not in academia, but you work as a professional, you work in the oil and gas industry, you work in the healthcare industry, you work in the pharmaceutical industry, and so forth, everything that you have done that have contributed to the industry overall, that will be justified through letters of recommendation. So the letters of recommendation, as I said, will tell a story. We'll talk about your past, we'll talk about your present, and also the future, how the signers perceive you doing that type of work in the US, and how the United States will benefit from having you in the US. If you are someone that is heavily involved in policy making, if you are an innovator and you have patents, we have patents that have been already granted. What's very important though is that those patents are being commercialized more than just being granted. If you have just things that are on paper, that will not help much. Of course, it will help us to tell your story on how innovative you are, but it will not be as impactful as if you had that patent being commercialized. And then the proof of your impact to the industry. So if your salary is very high, that means that the industry values your work. That means that the industry understands that you bring a lot of impact and contributions to it. So again, if you are invited to review the work of others, if you have people that report to you within your company, or if you go and you are being invited by a university to speak to students, it means that you have the technical know-how and that it's very valuable. It means that you are well positioned to advance in your field of endeavor. So that it's usually the type of evidence that you can provide when you file a national interest waiver application. So far, so good. So far, so good, everybody. Can you give me a thumbs up or a thumbs down? I just want to know if I'm talking too much. Awesome. Okay, I see some comments there. Awesome. Okay, continuing then. So I think I talked about the basics of the EB-2 National Interest Waiver. Most likely, we have people here that already have their EB-2 NIWs approved, but then they are waiting for their priority date to become current in order to either apply for their adjustment of status applications or to attend their visa interview appointments at a U.S. consulate abroad. In the past, 2 years ago, that was not the case. Usually, you would apply for your EB-2 NIW, and if you were in the United States, you were able to also file your adjustment of status application, or if you had your EB-2 NIW approved or I-140 petition approved, you would be able to continue your process at the consular level easily. But 2 years ago, that changed, okay? That means you can file your I-140 petition at any time during the year. By the time you file your I-140 petition, you get something called a priority date. And then every month, the Department of State will release a date that the priority date, they are accepting the acceptance of adjustment of status applications or the actual issuance of green cards, okay? This table, this release is called Visa Bulletin. And why is that? By law, the United States can only issue a certain number of visas per green card category per fiscal year. The fiscal year starts every October 1st and goes all the way to September 30th of the next year. And in addition to each visa, each type of visa category having a certain number of visas that can be issued per year, that is also capped by country of birth. And the reason for that is that the United States government wants to diversify the people that live in the country. So if you talk, for example, with someone from India or someone from China, someone from Mexico, the Philippines, you learn that their waiting time is way longer than people from other countries. And the reason for that is because there are so many of them already in the United States that new people that were born in those countries that are trying to come to the US to immigrate, they have to wait longer, okay? So 2 years ago, this changed for everybody else that were not born in India, China, Mexico, the Philippines. And the waiting time, it's longer, much longer than before. So now if you have an I-140 petition, you would have to wait, I would say, at least 1 to 1.5 years before you are able to file either your adjustment of status application, in that case, a little bit longer to have your green card issued, okay? So that's how the visa bulletin works, and that's the importance of your priority date. When you look at the visa bulletin, and you can Google now, visa bulletin, and you go to the Department of State's website, and you see that there are two types of tables. The first one is called final action, and the other one is called date for filing. If you are outside the US, you are processing your case at a US consulate, you have to focus on the final action table, all right? The date for filing table will not have any value for you. However, if you are inside the United States, depending on which table USCIS, the United States Citizenship and Immigration Services, is using for that month, if they say that they are using the date for filing table, you are able to file your adjustment of status application, even though you might not be able to get your green card issued right away. You're going to be able to request, for example, your work permit. You're going to be able to request your travel permit. So if you are in the United States, you have to pay attention and look at which table USCIS is using at that month for the filing of the adjustment of status application. I was talking about the 2 years, right? Now, a year, 2.5 to be able to file the adjustment of status application. And I was talking about some letters, some numbers. So as I said, the EB-2 National Interest Waiver is the type of visa that you apply, and that will lead you to a green card. So that process has two phases. The first phase starts with the filing of the immigrant visa petition, also called Form I-140, and that application, that petition is filed with USCIS, which stands for United States Citizenship and Immigration Services, the agency of the executive branch that has jurisdiction to approve visas, citizenship, and so forth. Applications, right? Citizenship applications. Once you file this petition, you have the option to pay a premium processing fee, and a decision will come within 45 business days. A decision doesn't mean that the case will be approved. It can be denied as well. The government can request more evidence, or the government can issue a notice of intent to deny. If you get a notice of intent to deny, you're going to have 33 days to respond. If you get a request for evidence, you have up to 87 days to respond. And then, of course, if the case is approved, great. You just have to wait for your priority date to become current to move forward with the next step of the process. Or if the case is denied, then you're going to have the option to either appeal or refile your petition. The second phase of the process is the filing of the adjustment of status application, or you starting the process with the National Visa Center to move forward with your consular filing application, okay? And that one is done, of course, with a US consulate or embassy abroad. And for that, you have to look into the priority date. The processing time for the I-140 without paying the premium processing fee that I said the government will have up to 45 business days to provide a response is about now, I would say 8. I have seen cases being adjudicated in 6 months up to 18 months. And then for the adjustment of status and consular filing, as I said, for the adjustment of status, I would say 1 year to 1.5 years from the time your I-140 is filed to file the adjustment of status application. And then for the consular filing, it's even longer than that, because now, even if your priority date is current, a lot of consulates are understaffed, and you're going to be waiting in line for a long time before your visa appointment interview can be scheduled. All right, so the whole processing time, I would say it takes between 2 years and 3 years nowadays. And that, of course, if you were born in China or if you were born in India, those processing times will be much longer than that, even 8 to 10 years, depending on, of course, if you receive a request for evidence or not. Mexicans and people from Philippines will not take that long. I know that I mentioned them before, but their waiting time is mostly related to the EB-3 visa.
So, Attorney Bruna, real quick, one question that they asked, I think it has to do with what you're talking about. Like, if you have another citizenship, can you use that instead of the country you're born?
No, unfortunately, it's your country of birth. There is something called cross-chargeability, where you can use the country of birth of your spouse. That's the only way that you can use someone else's country of birth or another country of birth. You cannot use your citizenship country. You can only use your country of birth. Or if you were born, of course, if you were born in a country where when your parents were not residing at that country, then of course you can request the government to use your parents' country of birth for the purposes of being qualified or waiting less time for a visa availability. But it's country of birth, cross-chargeability if your spouse was born in another country, or if you were born in that country while your parents were just visiting the country. They were not residents. Is that clear?
Yes, thank you.
All right. So those are the main differences between applying for NIW through adjustment of status and consular filing. As of now, if you file an adjustment of status application in the US, the government is not scheduling an interview yet, but I believe that will be standard, because when Trump was president the first time, that was his practice. Everybody had to attend an interview before the green card could be issued. At the consular level, everybody has to attend an interview in person. And the documentation that you have to provide, that you don't have to provide at the adjustment of status application, are your police clearances, police certificates for every country that you have lived since you turned 16. Of course, there are some rules around that, if you have lived in that country for less than 6 months and so forth. So that's something that's just a generic information. Police clearances. You only need police clearances in the US in case you have a criminal record, and then you have to show the disposition of that case and show that everything is clear. In both cases, you have to undergo a medical examination. You have to see a doctor. You have to see that you have taken some vaccinations. COVID is not a requirement anymore for people that are curious about that. And the benefit of applying for an adjustment of status is that you also have the option to request a work permit and a travel permit while the process is pending. If you decide to process your case via consulate, you don't have that option. Once you get your immigrant visa on your passport, you can travel to the US, and then by the time you enter the US, you become a lawful permanent resident right away. And you're gonna have the right to work, the right to travel, and everything else. Even though I put here that the processing time for consular filings between 6 to 12 months, that's not necessarily super accurate, because as I said, consulates are super backlogged because they are understaffed. So again, even if you have a priority date that is current, not necessarily your appointment is being scheduled. Whereas here with the adjustment of status applications, things are moving pretty quickly. There are no delays whatsoever. The problem here is just waiting for the priority date to become current. Now, to, I guess, some of the questions that were part of the DS 260 form for a long, long time. But then now, during this, even during Biden, it started in the Biden administration, it's now being extended into the Trump administration, that consular officers are really being super picky on how you answer those questions. And they are having a huge impact on visa adjudications for healthcare professionals. So people think that those questions were just added to the form DS 260, which is not true. This has been around for a long, long time. And I believe this is something that I predicted 4 years ago when we had a huge wave of people applying for national interest waivers. And people are, I mean, there was a huge marketing around it, a lot of companies offering it, a lot of people applying for it. And now we are seeing some of the negative impact of some of the practices that some of those companies were performing at the time and still performing. And then people are having their visas denied and even green cards being revoked. But I will talk about that now. So there are 3 questions that are super tricky when you open the DS 260, and those questions are only on that form for people that are applying for an immigrant visa abroad. So you got your I-140 approved, and now you are attending your visa appointment at a U.S. consulate or embassy abroad, okay? And that only relates to, I mean, 2 of them, to healthcare professionals. The first question about performing skilled or unskilled labor would mainly affect people that applied for a PERM or a labor certification, but I will go over them now with you. The first one reads, do you seek to enter the United States for the purpose of performing skilled or unskilled labor, but have not yet been certified by the Secretary of Labor? So this is basically what I was referring to when I was explaining that you don't need a job offer, because you are persuading the US government that your field of endeavor has national importance, and therefore you don't need a job offer. But the regular type of green card, for the regular type of green card, you need a US employer to justify that there are no US workers that are available, interested, or qualified for the position being offered. And this is basically the certification that you get from the Secretary of Labor, Department of Labor, to work in the US. So if you are going through a labor certification application and then you intend to come to the US and you don't have that certification yet, that's the tricky question, okay? The second question is, are you a graduate of a foreign medical school seeking to perform medical services in the United States, but have not yet passed the National Board of Medical Examiners examination or its equivalent? So what happened was that a lot of doctors were applying for I-140s. They were still studying for their, still studying to take the steps, right? And they were getting their I-140s approved at USCIS, and now they are attending their visa appointments at the US consulate. Some of them are not paying attention to that question, answering it wrongly, or if one is answering wrongly and the other one is not having the license, of course, so not having passed the exam. And now consular officers are putting the case into administrative processing and sending their petitions back to USCIS for revocation. because they said, well, my field of endeavor is to be a doctor in the US. However, they didn't have the license, or they haven't passed the exam yet. So they say, how come you are saying that you want to do that, but you are not even ready for that? So this is something that I said I predicted 4 years ago, when I work with healthcare professionals and my clients don't have a license yet, or they haven't started working towards getting a license yet, I would talk to my client and really strategize and talk about, well, you can do other things that are still related to the medical field, but you don't have to be a doctor to perform those duties. For example, research, for example, teaching, or working in a lab, and so forth. So now I have a lot of potential clients and people that are getting their visas denied based on that only. All right, so pay attention to that. The third question is, and this one is very open-ended. Okay, you have to really, really read between the lines here. Are you a healthcare worker seeking to perform such work in the United States, but have not yet received certification from the Commission on Graduates of Foreign Nursing Schools, or from an equivalent approved independent credentialing organization? So you look at the first part of the question and you think about nurses only, but the second part really, really expand to other type of professions too. So be careful. I don't wanna name professions here, because I don't want the government to target those professions. Talk to us in private, but this is something that other professionals, not only nurses, can be affected as well. So, as I said before, those questions, when you are answering any type of form, people think about the forms as something very trivial, but they are not. The questions are very tricky. And when you sign those forms, remember, you are signing them under penalty of perjury. So not only if you don't understand a question and you answer wrongly, you can be found ineligible because you are committing fraud, because you are seeking to get a visa by misrepresentation. And not everybody would qualify for a waiver for fraud, okay? So that's why understanding the questions and answering them correctly, it's super, super important. So one, when you are doing that, make sure that you hire an attorney that is experienced and can advise you correctly on how to answer those questions. And so this slide is super important, because when we get calls from potential clients, they talk a lot about, oh, are you gonna work on a business plan or a professional plan for me, right? The first thing I ask is, what is your plan? What do you want to do in the US? Because this process is not just paperwork. It's not something that you're going to be presenting to the government, you receive an approval, and then you go and you work with something else. No, that's not the intention, because at any time, the government can audit your business, can audit your case, can even, like in the future, when you are applying for your citizenship, this can hurt you. When you are sponsoring someone else for a visa, this can hurt you. So you cannot just be presenting paperwork that doesn't reflect the reality. So my first question is, what is your goal? What do you want to do in the US? And then we can develop the best strategy. Is that you plan to open a company, you plan to hire people, you plan to grow your business, you plan to put money in that business. So let's talk about a business plan, right? No, I don't want to open a business. My dream is to work for a multinational company. My goal is to be a consultant. Let's build a professional plan. Both options are very, very important. They are part of your national interest waiver petition. In the past, we used to send cases without those documents, and we would just present in case we had requests for evidence, but those were old times. Now it's a must in every national interest waiver application, and we help you with those two documents and also your personal statement, because we can write our briefs, and our briefs are amazing. It's not something that I'm bragging about just because I should brag about. I want to brag about because I have compared our work with other people's work, and our work is amazing. And you can talk with our clients; they'll talk about our brief as it's a piece of work. It's really, really nice. So our brief will talk about the legal aspect of the application. Our brief will talk about you. However, the government will look at what you are signing, what you intend to do in the US. So the professional plan and the business plan will be doing that. The business plan will cover the growth of your business for 5 years, and then your professional plan as well. What do you intend to do? To teach, to research, to consult, to innovate, to, to open a startup, to attract investors. What is your plan? So when we talk plan, we talk business plan, we talk professional plan, and then your personal statement will come and glue those pieces together to the evidence that we're going to be presenting to immigration. Now, you have seen a lot of people talking about real ID, right, online, because now it's mandatory. And you are also talking about the priority date. So I will try to be as clear as possible on that, but if it's not clear for you, you can ask questions during the Q&A session. Remember that I was talking about the priority date. So by law, okay, as a rule of thumb, if you are inside the United States and you want to apply for an adjustment of status, you have to be maintaining a lawful presence. You have to have a valid I-94. There is an exception to that rule for people that are applying under the EB-1, EB-2, or EB-3 visa categories. Whereas if you have less than 6 months of illegal presence, or if you have less than 6 months of unauthorized work, you can still file for your adjustment of status application and not require a waiver for those violations. And this is covered under the INA section 245K. So in the past, I would tell my clients, well, this is feasible. That's okay to remain in the US for 6 months with your I-94 expired. However, this is not the case anymore, because you see ICE, you see CBP, you see other agencies that are partnering with ICE, with the Department of Homeland Security, and they are looking for people in the US that don't have status. Especially now with that Colorado attack that we had, I guess it was on Friday or Saturday, of a person that came to the US with a visa, overstayed, filed for asylum. So now they are talking about, well, you were focusing on the people that just entered the US illegally. Let's talk about the people that entered legally and that now they are unauthorized in the US. So now it gives me chills to think about my clients that are in that situation. So I don't recommend you going this path, because now, if you are in those 6 months without a status, if you are stopped by an officer, you can easily go to jail. Okay, so that's one of the things. The other thing is, of course, you can use your passport to travel, but if you want to, for example, get a real ID, you are not gonna be able to get it, because you need proof of your valid immigration status to get this BRIO ID. And of course, if you go to an airport, you are subject to to search, because it's a federal facility, it's a federal territory, and at any time you can get some officer looking at your paperwork and so forth. So you're gonna be in jeopardy there. So that's why I don't recommend going through this route at this point. So therefore, it is important that you maintain a legal status throughout the whole process. Even after you file your adjustment of status application, sometimes I'm even recommending my clients to keep, for example, if they have a student visa, to continue studying. If they have a work visa, keep that work visa valid, because it's never the end until it is the end. So until you have your green card, you never know what can happen, right? The other important information for those of you who are in the United States is that now, once you file an application to change your status, to extend your status, and that application is denied, and your I-94 has already expired, USCIS, it's now enforcing deportation matters towards those people. So in the past, USCIS would deny a visa or deny an application and not do anything. And now what they are doing is, instead of referring the case to ICE, so ICE can start a deportation proceeding, USCIS can do that on their own accord, okay? So now, even before you file an application or a petition with USCIS to change or extend your status, make sure that you have a strong case, that you are not putting yourself into a worse situation than you are, all right? The other important information is that they are enforcing expedited removal rules for people that are inside the United States illegally for less than 2 years. So expedited removal, it's basically that horror stories that you hear of people trying to enter the US at the airport, and then the officer says, no, I don't allow you to come in, and now we'll deport you, and now you have a 5-year ban. You are not allowed to return to the US during those 5 years. So they are now doing that for people that are inside the US for less than 2 years, but in an illegal status, all right? So that's why it is important that you keep proof of your legal status. I don't recommend you carrying an identity from your country of citizenship. I just recommend you carrying documentation that was issued by the US government. We have a flyer that we can share with you if you are illegal in the country, of what you can and cannot do to minimize your exposure to any type of deportation proceedings or even being deported. But that's our advice. So I covered that. Now, that's important as well. That's something that we have seen in the past working, and that's now, I don't believe that was something that the USCIS just discovered now, but it's something that the United States government started to enforce it now. So just to, I guess, to make it easy for you, I will give you an example. So let's say you came to the US 3 years ago with your tourist visa, because all your friends came with a tourist visa, and they said, well, after you have been here for 3 months, you can apply for your EB-2 NIW, and you can apply for your adjustment of status application, and you can get a work permit, you can get a travel permit, you're gonna get a social security number, so you're gonna be 100% functional in the US. Now, those cases were ultimately denied, right? So they would deny the I-140 petition, but the adjustment of status would have kept open. And what they would do is they would file a new I-140 petition, interfile, and then say, now I want you to use that adjustment of status application that is pending and connect it to my new I-140 petition. And eventually, let's say this I-140 petition gets approved, then the adjustment of status was approved as well. And that person gets a green card. This is called an interfiling, but an interfiling done wrong. You cannot interfile an I-140 petition with an adjustment of status application that was based on an I-140 that was denied. That cannot be done. This is not permissible. But there was an oversight of USCIS, so people would get a green card, and now what's happening is that those people are getting those green cards revoked. Okay. So some of the practices that were being, I guess, performed in the past, this is not now good practice anymore. All right. So that's it for today. I guess I covered a lot of things during this presentation.
Yes. So the question is, how does the O1 visa work while I'm thinking about applying for an EB-2 NIW, or I have already applied for an EB-2 NIW? Is there a conflict of interest? Do you need a company to sponsor me, or can I sponsor the O1 myself? And is that any faster than the EB?
So the O1 visa is great, especially if you qualify for an EB-2 National Interest Waiver, or even an EB-1. Of course, the O1 criteria is most related to the EB-1A criteria. It's a great option, especially because it's faster to get than an EB-2 NIW. You can pay a premium processing fee and receive a decision in 15 business days. The problem with that is your spouse cannot work as your dependent. However, you can self-sponsor. You don't need an employer for that. And it's considered a semi-dual intent visa, meaning by the time you file your adjustment of status application, it's not recommended. And for me, I don't allow my clients to travel with the O1 at all, because your adjustment of status application can be deemed abandoned. So I recommend that you file, and once you file your adjustment of status application, you also request your parole to travel abroad. But that's the only risk associated with it. You cannot keep the O1 travel and the adjustment of status.
Okay, so I have another question thank you, Attorney Bruna. I'm currently sponsoring an F1 student who is submitting for an EB visa. What happened between the time that they are F1 and EB? I believe the question is why they're in process of the EB. Do they need to continue studying? Will this end my sponsorship of student? If so, will USCIS send me a letter telling me this? So I believe it may be an EB-3 process or EB, not sure.
It might be a labor certification, I guess. So it's once you get into the adjustment of status phase, that's the time that the person that you are sponsoring would not be required to keep a status anymore. However, by regulation, and even my recommendation is that they keep their visas until the green card is issued, until they get an employment authorization document and a parole, they travel abroad, come back as a parolee. That's my recommendation. However, it has been a long-standing practice to wait until the adjustment of status application is filed to stop studying. So this is a must. They need to keep a status valid at all times. As far as USCIS revoking your decision to be the sponsor of the F1 visa, this is not something for them to decide. This is for you to decide. If you don't want to be the sponsor anymore, you can send a letter to USCIS and also to the school withdrawing your sponsorship. But even if when you send a letter, USCIS is very, how can I say, disorganized, because you send a letter to a mail room, and not always that mail room will send the letter to the officer that adjudicated the F1 visa application, for example. But you can also send that letter to the school, and the school might be able to add a note into the civis record of the student.
Okay, so another question is, for the professional license, would Canadian professional engineer meet the criteria? I believe here it's asking about whether or not you need a PE, but maybe the PE is not necessarily needed for engineer.
Yes, so that would be, you can use the license to meet the exceptional ability criteria if you don't qualify for the advanced degree. And you can also use it to show that you are well positioned to advance on your field of endeavor. Because you can say, since I have a license already in another country, I aim, for example, to also get a license in the US.
Okay, so that's a good thing. So another one is, can I apply even if I already have an L1B visa? Will that impact my status with the company and inside the US? And if I apply in my application that being rejected, or I believe means denied, will this impact my current status as L1B visa holder while I'm applying to it? Or can I continue to work on the company? So I think the goal here is to know what's going to change if you apply for that 140 and that's denied.
So it will not impact your L1 status at all, because the L1 is considered a dual intent visa, both an L1 and H1B. Meaning if you apply for an I-140, an I-130, labor certification, any type of application that is related to a permanent residency status, that will not impact your ability to keep that temporary visa. And as a matter of fact, the majority of the EB-2 and NIWs that we process are for people that are here in the US with L visas or H-1Bs that work for a company, and the company is not willing to sponsor their green cards.
Okay. If I had a J1 visa with 2 years rule, left the US to comply with that rule and actually already complied with it, can I apply for the EB-2 visa?
Yeah, so so just for you to know, you can file the I-140 petition even with the 2 years home residency requirement. You need to show that you have fulfilled the 2 years home residency requirement either through a waiver or by spending the 2 years at your country of residence or birth. By the time you attend your visa interview appointment at US consulate, or by the time you file your adjustment of status application.
Perfect. So another question is, this is a little bit more elaborated. I have a process of EB-2 since 2023. I believe it's EB-2 NIW. And I receive a request for evidence. I also make an application for a O1A visa, work visa, just to stay legal in the US, which is still in process as well. Could be a good idea to do the change of status for EB-2. I believe it's assuming that it's current, which I don't think it is yet, but yeah.
Yes, if it's, I would say if it is current, I wouldn't yet until you hear back on the O1. However, if your O1 is denied, you have to look at whether you qualify under the 245K, because remember, you can only have 6 months of I-94 gap.
Yep, that's clear. And I think again, guys, everybody, watch this. You can always get in touch with us, and we can clarify the questions you have. So another question is, if I have an MA and PhD from the US university, does that mean that I have a US professional license?
It means that you have an advanced degree. The license is actually, I don't know what is your profession, but it's the actual right to practice a profession. For example, I have an LLM, right? I have a master's, but I am not an attorney because I have an LLM. I am an attorney because I have the bar license. That's a professional license. So same thing with you. I don't know what's your profession, but if it's a profession that you need a license to practice, the fact that you have a degree doesn't mean that you have the license.
Okay. If my client gets a United States MBA, that does qualify for a requirement for the EB-2, I believe you just answered it, right? So it's gonna
Yes,
means that you have an advanced degree, correct?
correct. You need to look at whether the school is accredited by the Department of Education, but usually yes.
Another question is, can you apply if you have an H-1B visa? Maybe you can talk about the other visa as well. So also what happened with this my spouse that has a H-4 if I apply for the EB-2 NIW?
Right. So the just remember, you can even apply for an EB-2 NIW even if you are not in the US. If you never had a US visa, you can still apply for the EB-2 NIW. So the fact that you have an H-1B visa will not change your qualifications for the visa. Of course, having the H-1B visa will help you to travel back and forth, and it will also help with our argument when we talk about how well positioned you are to um, develop your field of endeavor because you are already in the US, you already have someone that is interested in your job because you are employed and so forth. But yes, you can apply. Now, how having an I-140 helps with someone that has a spouse who has an H-4 and is not doesn't have work authorization yet. So if you file an I-140 petition and that I-140 petition is approved and your priority date is not yet current, you can go ahead, your spouse can go ahead and file request a work permit. So that's the benefit of having an I-140 approved for your spouse that has an H-4.
So a quick question. I think that's just to validate a comment. Did I understand correctly that you support many clients on L1A whose green card application are not being sponsored by their employer or company? Is that possible to transition to the green card from L1A without the employer? So the answer, yes. Go ahead, attorney.
Yes. But then in that case, let's say you qualify for an L1A because you were a manager abroad and you are a manager in the US, you would qualify for an EB-1C, which is a much quicker type of green card when compared to the EB-2 NIW. But if you don't have your employer's blessing on that and you have to file an EB-2 NIW, you can do that, no problem.
This one
Then,
is
as
a
far as
question.
the cost for the premium processing fee, if you are talking about the I-140 petition, yes, that's the $2,805 that Jose put it on the chat.
So on from the Instagram channel, they asking, I belong to a doctors WhatsApp group where a lot of people are getting denied because they mentioned that they are medical doctors. I think you already covered that, attorney, but I think they're asking if they had mentioned something else like research, would benefit their interview case?
Of course, and of course, the intention has to be that, right? You are not, as I said, you are not just putting something on paper to get your case approved. You are writing something that it's indeed the truth. So, yes, so you can put into your I-140 petition an ONET code, which is a job classification that it's not related to a position that requires a license.
Another, I guess, I'm not. The one is you guys are mentioning the professional plan instead of business plan. All the consultation company, they offer me the business plan. Why is that? So I think you already mentioned that as well, correct? I mean, why?
Yeah, it
What?
might be that the person is talking about opening a company If this is not the case, then most likely, I don't know if you are professionally qualified to provide consultations. I don't know. If you want to send your resume to us, I'll be happy to look at it and provide my take on it.
Okay, I think the main questions we already covered. One of them I can answer myself. Basically, asking how much you charge to talk about EB-2 with the team, so that it's if basically there's no cost to discuss with the team about this process. Of course, if you need a consultation for our attorney Bruno, there is a fee for it, but we do have a channel. You guys can book it online. I think that's pretty much it, Attorney Bruna. And everybody else, I'd like to appreciate everyone. I know there are a lot of Brazilians are here, and there's a game going on right now, so I really appreciate your time and the effort to be available. Everybody gonna receive an email with our link for this video, so it's gonna be published. Don't worry, your name is not gonna be on it. It's gonna be everybody is gonna be removed except Attorney Bruna. And I think that's pretty much it. Any final words, Attorney Bruno, would like to add?
No, I just want to thank you everybody for attending, and we are here to help you out throughout your journey.